Hi everyone, and thank you so much for joining today's webinar. My name is Hugues Plessir, and I'm a senior attorney at Scott Legal PC. Today we are going to spend some time talking about the EB2 National Interest Waiver. This is a green card option and a very special option because it's not only underutilized category of green cards, it's also available for entrepreneurs, so those who own their own company. It's a very good option for those. It's also becoming a more and more popular option for individuals in the US, especially those who are currently on an E2 investor visa, which is a non-immigrant category. We are very fortunate today to have my colleague, Jiyae and Hugues, presenting on the topic. Jiyae is a senior associate within the firm as well, with significant experience preparing national interest waiver petitions. So today we also probably going to use the short for national interest waiver, which is the acronym NIW. A few things before we get started with the presentation. This webinar is being recorded, and we will share this recording with you after. So after this webinar, we will send you a link to access the recording, as well as a link to the PowerPoint presentation that's on the screen right now. And we will also send you an NIW comprehensive guide that gathers the best information we have on this green card category. We will also send a link to register for future webinars. We try to do a few of these webinars each month, and it usually covers, the brand range of US immigration topics. Our law firm focuses on US business immigration, but if you need assistance or if you need information about other US immigration matters, such as familial immigration or humanitarian matters, please feel free to reach out, and we also have some webinars on those topics. This email that we will send you will also have a link to our YouTube channel, which has the recordings for the webinars, but also short form content on a broad range of US immigration topics. And it's really an excellent source for all things US immigration. So I would highly recommend that you check it out. And as I was saying, if you need assistance, please do not hesitate to reach out. We have a consultation system on our website, so feel free to visit our website as well. If you have any questions during this presentation today, please feel free to type them in either the Q&A box or in the chat function of Zoom. I will monitor the questions, and then we will answer all the questions at the end of the presentation if there is not the answer in the presentation. I think that's pretty much it. Without further ado, I will go ahead and pass it on to Jiyae for the presentation.
Great, thank you, Hugues. Right, so let's start with, talking a little bit about what the NIW is and how you can qualify for a green card under the EB2 NIW program. So the NIW, as Hugues mentioned, is short for National Interest Waiver, and it is a subset of the EB2 employment-based immigrant petition. An immigrant petition means this is an application for a green card, which is U.S. permanent resident status. And a green card gives somebody the ability to live permanently in the United States and work for any employer they want or not at all. And having a green card also opens up the pathway to U.S. citizenship in the future. So the EB2 NIW is a popular choice among individuals who may want to apply for a green card on their own. And this is called self-petitioning. And that means you're applying as an individual, whereas normally you need a U.S. company to sponsor you for a green card with a job offer. So that's the traditional way to go about immigrant, worker petitions. But if you can qualify for the EB2 NIW, you yourself can be the driver of the petition. So that is why it has really surfaced as a popular category in recent years. So the EB1A is another category of a green card that allows self-petitioning, right? So the EB1A is a category for extraordinary ability individuals, people who have reached the top 1% of their fields, and can be option for some people, but the EB2 NIW is a more broader option available to, a wider variety of professionals, even if they have not reached that top 1% stature. You can still self-petition for a green card if you can show that your work will make significant contributions of national importance to the industry or society, and that you're well positioned to do this work. So let's go a little bit into the weeds and discuss what are the eligibility criteria for an NIW. So the first thing to note here is that for all EB2 petitions, both NIW and for employer-sponsored petition, you need to meet the EB2 threshold category. And there are two ways to meet the threshold category. The first way is to show that you have an advanced degree. It is defined as a master's degree or higher and includes things like PhD degree, even an MD degree or a JD degree, for example, which are first professional degrees. They can also be considered a master's level degree because you need a bachelor's degree in order to gain admission to those kinds of programs. An MBA, for example, a lot of our clients have an MBA. That can also count as the advanced degree needed for the NIW petition to qualify for the EB2 threshold. Now, if you have a foreign degree from a foreign institution, which is not a US institution, you will also need to submit what is called a US Education Equivalency Assessment. It is a report that, basically confirms that your degree is equivalent to the same level degree, master's or above, in the US standard. So keep that in mind. Now, if you don't have a master's degree, but if you have a bachelor's degree in your field and over 5 or more years of progressive work experience in your specialty following your bachelor's degree, then you could also be considered as someone who has the equivalent of a master's degree in your field. Now, it is important to note that the 5 years of work experience must be progressive. And what that means is your work experience and your work duties did not stay the same over the 5 years that, we're trying to prove. You should show that you were asked to do more complex duties, for example, more senior responsibilities as the 5 years went on, such that, the USCIS would expect to see a very detailed employment confirmation letter showing not only that you've worked full-time for the 5 years, but also your duties have changed in seniority over time in a progressive manner. You can also show that with, an increasing degree of, title, for example, going from junior professional to senior professional to partner, for example, or a rise in salary that is commensurate with, the changes in responsibility. Now, let's say you don't have a master's, let's say you don't have a bachelor's, and let's say, maybe you don't have 5 years of experience. Is there another way to qualify under the EB2 threshold? And there is. The other way is to show that you have exceptional ability in the sciences, arts, or business. And it is a two-part test to determine if you have exceptional ability. And mind you, that exceptional ability is very different from extraordinary ability that is required for EB1A petitions, and it is a much lower standard to meet. So for example, if you can show at least 3 out of the 7 criteria of evidences that is listed here, which can include 10 years of experience in your field. If you have any degree, even if it's a diploma, even if it's a certificate, you can maybe use that. If you have a related license or membership in professional associations, you can also use that as evidence. Importantly, one criteria of evidence is showing that you have earned recognition in your field for significant contributions in the field, such as awards, original research that you have published in, journals or patents or things like that. Those can be very good examples of significant recognition. If you played leadership roles in, leading associations, professional associations, and have impacted the field in some way, and if you can get expert letters to prove that, those are can be very helpful evidences to show recognition. And also high salary. Cumulatively, the evidence should holistically show that you are someone who is a professional who is operating at a level that is significantly above what is ordinarily encountered in the field. So that degree of comparison is what they're looking for. You don't need to show that you're at the top 1% of your field like the EB1A would do, but it is a lower standard that you still must meet to qualify as an individual of exceptional ability. Now, once you have done that, once you have shown that you're eligible for the EB2 threshold category, the other major part of an NIW application is to show that you meet the 3-pronged matter of Danaher criteria for an NIW. And the reason why this is important is because the NIW basically is an exemption. It's a privilege from your requirement, the ordinary requirement to go through the labor certification process with a US-based company with a US-based job offer. And to show that your case is basically, advanced enough, so more meritorious, basically, to exempt, to merit this exemption, you do need to meet all three criteria that are listed here. So the first criteria is to prove that your specific proposed endeavor in the United States has both substantial merit and national importance. And what does that mean? So substantial merit can be proven in a range of fields, including the arts, the sciences, business, even culture. And usually, if your endeavor is something that advances human knowledge in some way in any of these fields, that can very well be found to have substantial merit. Now, what is found as national importance? So national importance is defined as, an endeavor that has broader implications to a certain field, which goes beyond just improving the profits of one particular company, or serving the interest of your direct client, but you're doing something that will advance the industry or technology more broadly, right? So if your endeavor has national or global implication in that field by, changing the way, a particular approach is conceived in a field of science, for example, right? So you're developing a new theory, or you're developing a new technology that can be used by other experts in your field to also improve their own practices, or such as medical advances, for example. If you're developing a new treatment that was previously unavailable for a particular disease that can help millions of people, potentially improve their prognoses. So those kinds of broader impact is what the government is looking for when they're looking for national importance. The other criteria, the second criteria, is that you yourself, the foreign national themselves, must be well positioned to advance the proposed endeavor. And this can be proven through, the person's education, relevant experience, and really the government is looking for the evidence that shows a record of success in that particular field that will give them the unique skills and know-how to drive forward the endeavor, that can impact the field more broadly. So this can, really be a portfolio of previous projects that the person has done, that not only shows that the person's work, impacted their immediate employer or immediate clients, but also did something that advanced the industry as a whole, or had a broader impact to improving best practices in that particular field. So the third and last requirement to meet is that there must be a showing that on balance, it would be beneficial to the United States to waive the requirements of a job offer and thus of a labor certification for that particular case. And for the third prong, it is really a balancing exercise. So the normal benefits of a labor certification is that you're protecting the US domestic labor supply. However, in some cases, in some projects that a foreign national does, the expected benefits of such a project is so large, it's so major, that it outweighs the ordinary benefits of saving that one job spot for one US person. So if you can show that either the prospective impact of your work will result in, even more job creation, for example, if you're an entrepreneur, if you will create significant number of jobs in an economically depressed area, for example, that will clearly outweigh the benefits of saving one job spot for one worker. Or you can, talk a little bit about your unique experiences that cannot easily be replaced by a US worker with minimum credentials, because that is the usual, requirement for labor certification. If you can find someone else in the US who can do it, who has the minimum credentials, then, the perm process has to stop. But if you have these particular experiences that is at the cutting edge of the industry that can't really be found in the general body of practitioners, that can also be another reason why, on balance, it would be beneficial to exempt you from this particular requirement. All right, so we'll go on to the next slide. So then let's talk a little bit about NIW for entrepreneurs. How can the NIW can be used for entrepreneurs to get a green card? So a couple of things to note. The matter of DANISR is the new case law that came out in 2016, promulgating the new three-prong test that I mentioned before. And in that case law, the government mentions that the benefit to the US can be geographically local as well. So before matter of Dinosaur, the inquiry for national importance really focused on the geographic scope of the work. But after matter of Dinosaur, even if your business or even if your endeavor is geographically limited to one particular state or one particular region, the impact can be seen as national importance, depending on what it is, right? So for example, if you are putting in significant investment and capital into a particular economically depressed region, and if you're going to be hiring a high proportion of workers in that region, even if the benefits are concentrated there, the government has stated in matter of Dinosaur, the case law, that such an endeavor can be said to have national importance, and they say, and I quote, substantial economic benefit to a economically depressed area. So that can be one way to find national importance. The other thing that the case law explicitly discusses is that entrepreneurs are usually self-employed. And thus, the traditional green card pathway through a job offer and sponsorship by a US company may not always work because entrepreneurs typically have ownership in their companies. And for the traditional labor certification process to work, you can't really have ownership in the company that's trying to sponsor you. That kind of undercuts the idea that it is a bona fide job offer. So the case law in matter of Dinosaur explicitly notes that and says that the NIW could be a way to fill the gaps in those areas where it is just impossible for an entrepreneur to benefit from, the traditional labor certification requirement. So that means that when we're arguing the on balance third prong, on balance, it's more beneficial to, grant this exemption. The entrepreneurs are able to use that argument, saying that it is impractical for entrepreneurs to take advantage of the traditional labor certification system. Finally, Dinosaur specifically notes they discuss that entrepreneurial work can lead to an NIW, encouraging that this is a possibility for entrepreneurs. And the planned venture does not even need to ultimately succeed, provided that the entrepreneur's proposed endeavor has the potential to succeed and can present, a plausible basis to find a outsized impact to the industry or society based on their business plans. All right, so we'll go on to the next slide. So then let's shift gears a little bit and talk a little bit about the practical and strategic considerations when you're trying to move from a non-immigrant visa to an NIW. And keep in mind that the NIW is an immigrant petition. So if you are in status, such as a TN visa, for example, where non-immigrant intent is a very important consideration, then filing the I-140, so filing the NIW application, right, could be seen as something that contraindicates non-immigrant intent, which could, depending on the circumstances, provide some risk. So then let's talk a little bit about timing first. So for NIW applications, and it is important to note at this stage that there are two steps to applying for a green card. The first step is the underlying petition, what is called the I-140, and that establishes your eligibility for the particular green card category. And once your I-140 is approved, then you're able to go to the second step, what is called, the actual green card petition. And there are two ways you can process the green card petition. The first way, if you're already in the United States on a different non-immigrant status, you can apply to adjust status by filing an I-485 to a green card holder. So that's the first way you can do it. The second way you can apply for the green card is if you're living in a foreign country and not in the United States, for example, you will need to do that, is to apply for an immigrant visa through your home country consulate, right? And you will, file what is called a DS-260, and then your home country consulate will invite you in for an interview. You would do the medical test and all that. And once you pass the interview, you will be given an immigrant visa stamp in your passport. And once you have that stamp, you can come in to the United States and do the landing, and your green card will be mailed to you. So that's the other way you can process the green card. But that is just to say that there are two steps to the green card process. We're talking about the first step here when we're talking about timing. For NIW applications for the underlying I-140, premium processing is available. If you pay extra, you can get an action from the government, either it be an approval or a request for evidence or a notice of intent to deny, for example. The government will respond to you within 45 calendar days. And in practice, we have also seen approvals that are much faster than 45 days. So they promise that they will get back to you within 45 calendar days, but they could get back to you earlier than that. If you use regular processing without premium processing, it usually means your petition, the I-140, the first step, will be being processed for over a year almost before you can get an answer from the government. For the second step, if you file immigrant visa application or if you file the I-485, that part can also take about a year. So it is important to note that there is the timing that's related to the I-140 part, and there is also the timing related to the I-485 part. And complicating that even further, currently there is a backlog in the EB2 NIW category, which means more people are applying and qualified for the NIW-based green card than there are visas available each year. And there is an annual limit, a quota, of immigrant visas, green cards available for each category every year. Every month, actually, there is a visa bulletin that shows exactly how long the backlog is. And right now, on average, we've been seeing a wait time of about a year, at least a year, for our clients to wait until their priority dates become current. Even if their I-140 is approved, they can't just go ahead and apply for the second step for the green card, by using a I-485 or consular visa processing process, if their priority dates are not current. So you do need to think of all of these different steps and the different delays that can be that you need to go through in order to get the green card in hand. And I would say so definitely budget maybe 2 to 3 years for the entire process. We have seen from I-140 to green card as quick as 1.5 years, maybe. And if you do, an I-485, for example, including the waiting time, but definitely a good idea to keep an eye on how the priority dates are moving, and keep in mind that it can be a multi-year process. So then let's talk a little bit about underlying visa status. If you are on a non-immigrant visa that does not allow for dual intent, such as a TN visa, which is particularly scrutinized often for immigrant intent. Once you file the I-140, you may encounter difficulties when you're applying to renew your visa or when you're applying for a visa at the same for the first time. Definitely speak to your attorney if you are navigating that kind of complexities. We'd be happy to advise you. With regarding the application process, and I did go into detail about this, submit the form I-140 first with the proof that you meet the eligibility criteria for that particular category, EB2 NIW, and wait until the immigrant visa is available before you can file the I-485. If the category is current, you can concurrently file the I-485 with the I-140. However, right now, as of the date of this webinar, there is still a backlog, which means you do need to wait a particular period of time before you will be allowed to move on to the next step for the green card. And is the category current? That's the topic that I just discussed regarding delays with the priority dates. Pros and cons of adjusting status in the United States versus consular processing. So the advantage of filing for an adjustment of status, that is the I-485 that I've been mentioning, is that you don't need to maintain an underlying status after you file the I-485. You can continue living in the United States and basically waiting for your green card to be adjudicated. You have the ability to continue staying in the US even if you don't have an underlying status anymore. And if you file the I-485, you can also apply for what is called an employment authorization card, an EAD. And if you get that, then you can use that EAD to work for any employer you want during the time that you're waiting for the adjudication on the I-485. So that can open up a lot of options for people who are in the United States. One disadvantage of applying for the green card using the I-485 is that you cannot travel outside of the United States while the I-485 is pending. unless if you also apply for a travel authorization document by filing what is called the I-131. Once you have that advanced parole document, you can use that to make international trips and come back in. But if you don't have that, you cannot travel outside of the United States while the I-45 is pending, because that will result in abandoning the petition. So that's one pretty important disadvantage that you should think about, because you may need to do international travels. And in that case, consular processing may be a better idea. If you use consular processing, the advantage is that you have no restrictions on traveling while your immigrant visa petition is pending. However, keep in mind that once you file the I-140 and once you have the immigrant petition ongoing, in particular instances, you may encounter some challenges depending on what status you're trying to come back in on, or depending on what visa you want to renew. Some visas, some visa categories like, the H-1B or the L-1, is dual intent, so you don't need to worry about immigrant intent. But other categories are, scrutinized more strictly on that, depending on how far you are in the process. Another disadvantage of consular processing is that if you want to be in the United States, you do need to have a separate basis of extending your stay, right? So filing the I-140 does not give you any independent basis to continue living in the United States. Only after you file the I-45, you do have that. So that is actually a common misconception that we usually get from clients. I filed an I-140, now can I just continue living in the US? And the answer is unfortunately no. Only after you file the I-485 can you stay in the United States. And if you're opting for consular processing, you don't get that advantage at all. So another strategy point to definitely talk to your lawyer about. All right, so we'll move on to the next topic. So then let's briefly discuss some updated guidelines that the government has published for STEM category applicants and entrepreneurs back in 2022. So the thing to note about STEM specific guidelines for the NIW is that the government has published a list of what they call critical and emerging technologies. And if you are someone who is doing research in those CNET technologies, or otherwise involved in advancing CNET technologies in some way, for example, if you're an entrepreneur and you're developing a patented a technology that improves artificial intelligence methodologies, I don't know, you can use that to support the national importance of your work, because the government has already promulgated that such areas are important for national security and it is important for strategic interest of the United States. So there is a list that the government publishes. I can give you some examples. They include, for example, advanced computing technologies, engineering materials, manufacturing, advanced sensing, aero engine technologies, agricultural technologies, AI, autonomous systems, biotech, communications and networking technologies like 5G networks, data science, data storage technologies, distributed ledger technologies, energy, medical and public health technologies, quantum science, semiconductors, and space technologies, all of these areas that the government thinks it is critical for national security interests in the future. If your proposed endeavor is related to advancing that, you will get a leg up in your EB2 NIW petition. The thing to note about entrepreneur-specific guidelines is that the guidelines really expanded the options of supporting evidence that entrepreneurs can use when they're trying to support the substantial merit and national importance of their work, and also that they're well positioned to advance their endeavor. Now, keep in mind that the EB2 NIW used to be a popular category for academics, people with PhDs who, primarily have journal publications with, dozens of citations and Google Scholar, things like that. And that is the traditional way applicants have usually attempted to describe their national impact. But with the new guidelines, entrepreneurs are given a much more broader set of evidences they can use, even if they have no citations, even if they have no publications. There are other ways they can prove a broad impact to the field. So let's discuss a couple of examples. If you can prove, for example, that you founded a startup and that startup gained admission into a prestigious incubator such as Y Combinator or Techstars or something like that, that in itself can also be seen as an independent validation of the industry disruptive potential of your work, which can really help with national importance and substantial merit, right? Another example is if your work has received governmental awards or grants directly from a related agency. So for example, if you are developing a particular agricultural device, and if you received, a grant from the USDA, right? That can be a direct evidence that your work has national significance. So those types of non-traditional ways to really support your national importance argument that can help. Media attention, for example, can also be one thing to use. And if your particular business project has received venture capital funding, significant venture capital funding, you can also use that as another way to support that your endeavor has an industry disruptive potential, which can support national importance and substantial merit. Another way that you can use non-traditional data is when you're trying to prove that you're well positioned to advance the endeavor as an entrepreneur. If you have a record of, significant growth in your business and US-based hiring, creation of jobs, you can use your corporate tax returns and W-2s, for example, to show that you have actually created this economic impact. If you also have, let's see, intellectual property that you have published, which is related to your endeavor, such as a patent that is registered to your company, even if your name is not registered as an inventor, you can still use that as evidence that you've already contributed to the development of technology in that particular area. And finally, what can be very helpful for entrepreneurs in particular is we've seen success in using contracts with leading industry actors, that can show that your work has already generated substantial interest in the industry. For example, if I'm someone who's developing novel architectural products, and if the Google headquarters has, signed a contract with me to implement this product in revamping their headquarters, I would certainly use that as that contract as an example that there has been actual industry interest in my particular business project, which can also help prove that your project has substantial merit and national importance as well. All right, so then let's go a little bit into the weeds and talk in more detail about what documents are included typically in an NIW submission. And the EB2 NIW submission typically tends to have many a high number of pages of documents. I've seen, 400, 600 pages of supporting evidence. And it usually becomes like that because we do need to prove not only that your proposed endeavor will have national importance, but also really show that a record of success exists that really position you well to drive forward the endeavor, and that your endeavor will do more than just benefit your immediate company or your immediate clients, but will result in broader impact to the industry. And how do you show broader impact to the industry? You need to really provide a detailed corroborating evidence, a body of corroborating evidence that shows that you have made such impact in the past. So let's go into a little bit more detail on what to include. So the first thing to note is the submission must include proof that you meet the threshold requirement for the EB2 category as a whole, right? So if you're meeting the requirement through an advanced degree, you would include the copy of the diploma for that particular degree. And if it is a foreign degree, you would include a US education equivalency assessment report to show that your degree is equivalent to a US degree in that particular level. If you're qualifying with a bachelor's degree and 5 years of progressive work experience, as I mentioned before, ensure to also include a employment confirmation letter from your previous employer that shows not only that you have 5 years of full-time work experience, but also a detailed enough discussion of your duties and responsibilities and how they changed over the years to really show this trajectory of progressively advancing work experience in the 5 years. The second part of the petition materials is evidence that you qualify for the National Interest Waiver, and evidence corresponding to all 3 prongs of the matter of Danaher criteria that I've been explaining in the previous slides. So for example, to support national importance and substantial merit, you can provide a body of evidence consisting of news articles, academic papers, relevant data, really showing what the limitations that the industry is currently having and how your particular work can help overcome that limitation, for example, or really to show what broad-based impact your work can have to your field, or to advancing U.S. governmental priorities. So, for example, if environmental sustainability is a policy priority of the United States, how can your work materially advance the way sustainability is done in that particular field? How can we quantify your prospective impact of your endeavor? If you are presenting a entrepreneurial proposed endeavor, it'll be a good idea to present a business plan, a very comprehensive business plan that explains exactly what you're doing that's distinguished from other practitioners in your field, but also something that quantifies the economic impact that your work can have to the region in terms of revenue generation, tax revenues to be generated, profits, and U.S. job creation. So if your endeavor is projecting to hire a high number of employees in the United States, you would use that in your business plan to substantiate the nature of the impact your work can have. Now, expert letters are another important part of an NIW petition, and they play a variety of roles. One role that the expert letters play is to demonstrate the substantial merit and national importance of your endeavor itself. Because these experts can, expert letters coming from leading players in the field can really provide a credible account of what the industry needs and what you're planning to do that can really improve the way things are done in your field. If you are going with the economic impact argument, for example, one other type of expert letters can be from an economist who can talk about the induced and indirect economic benefits in addition to the direct economic benefits that your business can have to the economy. So that kind of letter can also be helpful in particular circumstances. Other types of expert letters can really help develop the narrative of why you're well positioned to advance the endeavor. So if you have worked on previous projects that have been very successful, the expert letter can, provide the narrative of why it was so important to the field. Why did your work go beyond just benefiting your immediate employer or immediate clients, but why did it result in advancing the industry as a whole? So expert letters can really play a big role in contextualizing this narrative to the USCIS officer, really making the officer see that you do have outsized impact in your field, such that an NIW would be appropriate given the circumstances. Finally, you would include a body of corroborating evidence that will support all of these narratives that will be developed in the expert letter. So for example, you would include a resume discussing your previous achievements, proof of professional accomplishments, which can include, work product, publications, a record of, being invited to present at industry conferences, things like that. evidence of you being recognized as a leader in your field. Really, the NIW is a category of persuasion. And the more evidence you have of the outsized impact that you've had in the field and that you will have in the future, the stronger your case will be. And as I mentioned briefly before, for entrepreneurs, it is usually a good idea to include proof of contracts, letters of intent from, leading industry actors in your field, really showing that you have generated traction with your business project among, leaders in the U.S. industry, and that, your project is a real one and that it is likely to succeed and produce the outsized impact that we're planning to prove. All right, so for the last topic, let's discuss a case study regarding a successful NIW case filed on behalf of an entrepreneur, which was approved. So in that particular case, the applicant was an entrepreneur, and the proposed endeavor was to form a small consulting firm to work on projects focused on improving services to U.S. veterans. And in particular, what the company proposed to do was to coordinate with various philanthropy and government organizations in the US to put on projects to promote reintegration of wounded warriors, wounded veterans back into productive society. So if those veterans were having trouble, being linked to productive job opportunities or career training opportunities, those initiatives would help fill that gap. So this person included a comprehensive business plan describing exactly how this advocacy work will improve existing program offerings. And this plan was very specific and included specific names of the philanthropy organizations and government organizations that this person planned to work with for this particular project. In addition to the business plan, the file included government reports, news articles, and expert letters that really describe the compelling need to improve program offerings in this area, which really also helped show that improving services to U.S. veterans is a government priority for the United States. And it was really helpful to include expert letters from senior officials holding, high positions in such U.S.-based philanthropy and government organizations covering the field, confirming the impact that this person's project can have, the positive impact, and the need for such improvements for the field as a whole. Secondly, then, how did this person prove that he was well positioned to advance this particular endeavor? The key here was to provide enough evidence of a record of success in previous and related endeavors, and in this case, from his home country, which was the UK. So this person was able to get expert letters from very senior officials in UK organizations that was also covering the field, in which the letters described how he played a leading role in developing and implementing initiatives to connect these veterans with productive job opportunities. And in addition to that, these letters went very specific in talking about the real world impact, the extent of the impact this work has had in actually changing people's lives, changing hundreds of veterans' lives. And all of this narrative was reported in the expert letters and also corroborated by objective evidence that was also included in the petition, including news articles covering this work. So then let's move on to how we were able to prove on balance it was beneficial to the United States to waive the requirement of a job offer and labor certification for that particular individual. And the court opinion discussed several things. The first thing that the opinion noted was that as a self-employed entrepreneur, it would have been impractical for this person to obtain a labor certification due to, the nature of this person's ownership of that business project, business entity. And additionally, the value of the services that this person planned to provide was so impactful had such an outsized impact that would definitely outweigh the ordinary benefits of keeping one job spot for, a minimally qualified US worker. And finally, the level of expertise and the extensive network that this person had, and also the record of success that could really not be replicated by another person with minimum credentials, really militated towards the conclusion that it would benefit the United States to keep this person and harness this expertise rather than giving this spot to just another person who just has minimum credentials in the field of endeavor. So yeah, in conclusion, it was pretty much a no-brainer for the USCIS to approve this person's NIW petition. All right, so that is all of the content that we had prepared for you today, and I'm happy to answer questions.
Yeah, we have a couple of questions. So just a quick note that obviously we won't be able to, provide detailed information about someone's specific case, but Jiyae, can you just provide a little bit more information about supporting documentation? I know you've gone through great examples, but what about presenting a personal project at a tech meetup, for example, or contributing to an open source project? And having a couple of GitHub projects. That's one of the questions. Maybe if you can provide a little bit more information about supporting documentation and evidence, and I think to that point, maybe about being a little bit creative about what we provide.
Sure. Yeah. So we do take a tailored approach when we're working with supporting documentation to show the impact of your field and specifically how your work is being disseminated to others. So so what I think is really important is not necessarily the category of evidence, but really the substance of it, right? So in your field, like, what kind of tech meetup was it, right? Like how many attendees were at the tech meetup and how, who were at the tech meetup? Was it a meetup of CEOs at tech companies? Was it a meetup of, people who are, known as leaders in the field of data science that you're in, right? So obviously I can't really, speak to your particular facts, not being familiar with any of the details. So definitely sign up for a consultation with us where we will be able to look at your resume and have a more detailed conversation about it. But as a general matter, there really is no limitation on the types of evidence that we use to show, a broad impact to the field. We have used, unlikely things like, being invited to present at a podcast, industry podcast, for example. And that podcast actually had a lot of readership. It was a podcast that was distributed to many people, and we were able to prove that as one of the evidences of this person's particular influence in the field, because every field has different ways where knowledge is disseminated. So yeah, the types of evidence that we rely on really runs the gamut, and we would tailor the strategy to a person's particular background. And that is why you should probably, it is a good idea to work with a lawyer who's worked with a wide variety of fields. Sometimes for some client profiles, the traditional way of proving the influence just doesn't work. So hopefully
Great,
this is helpful. Yeah.
Yeah, very helpful. Another question we have here, it's about the endeavor. And the question is, how specific does the endeavor need to be? For instance, an engineer wishing to work in healthcare, but would be open to various projects.
Yeah, the endeavor should definitely be more specific than just proposing to work in a field. Because the danger with that is that the government will think, oh, okay, well, just by working in a field, like that doesn't give us enough data to really gauge the potential impact of your work. So I would definitely advise to develop the endeavor a little more and to at least be able to provide a very detailed plan of who you're going to work with, what you're going to do, who is supporting this work. Like, did you get a government grant for this particular research, for example, and how is it going to impact the field? And if you can provide a detailed overview of that to allow the USCIS to gauge the prospective impact, then that's the level of specificity that you need. So definitely a one-liner that, oh, well, I'm going to continue working in healthcare. That's definitely not going to work. But I guess it is sort of a spectrum of specificity where you do need to give the USCIS enough information for them to make a decision about whether it's nationally important or not.
All right, great, thanks. Another question we have here, thanking you, Jia, first for the very detailed presentation, and I concur that was very helpful. The question is about the relationship between a non-immigrant visa and the green card, the EB2. So question is whether or not, if you're on an E2, would it be a bad idea to have try to apply for an EB2 NIW, and wouldn't be good idea to do that because of the non-immigrant intent of the E2? So that's the first part of the question, if you can touch on that.
Sure. And so I'll talk a little bit about the E2, and then for the other part of the question, I think it's very fact specific around your endeavor. So I would suggest that you schedule a consultation with us where we would discuss that in more detail. But just to get back to you on the E2 visa question, we have seen many clients who were already on an E2 visa, and while they're in the United States on an E2, they applied for the NIW and was approved. And then they were able to move on to the I-485 portion with no problem. The E2 visa is a little tricky because it's not technically it's not a dual intent visa. But also the E2 visa is more lenient than other categories in terms of the impact of having filed an I-140. So definitely get in touch with a lawyer to really look into your particular facts in more detail. But generally speaking, it is possible to at least renew your E2 if you have it through USCIS. We've seen that happen. Now, what if you're applying for a new E2 visa at a foreign country's consulate? That could be another question that you want to think about, because depending on the consulate, they may have different ideas on the significance of having filed an I-140. So in that case, maybe a better strategy to renew your visa first and then file the EB2 I-140 to avoid any issues. So definitely speak with your lawyer to determine the best strategy there.
Yeah, definitely some timing considerations there. The other question that we have here is very similar. It's if someone's spouse has an E2 visa and that person's spouse apply for an NIW EB2, does it affect the ability of the spouse to renew the E2 visa and the dependent visa? But I think we sort of touched on that, but if you can just confirm, Gia.
Yeah, sure, we did. And if you're listed in the I-140, so in the I-140 there is a part where they ask the names of the dependents who may join the petition, and if your name was included in it, and if you clicked on yes, with regards to an interest in applying for the immigrant visa in the future, then yeah, it could affect your E2 renewal because that is also, kind of being petitioned for an immigrant petition. So yes, that could affect your case. Now, with regards to the E2, as I told you, there are some different considerations. In one area, the E2 is not a dual intent visa, but on the other hand, the E2 is also kind of a lenient category in that circumstances. So definitely speak to a lawyer to fully understand the risks.
Thank you. And just quick questions here. The question is about how to get equivalency documentation for, I assume, the degree, and how can I get that? How can someone get that in the US?
Sure. So there is a list of equivalency assessment organizations you can look up online. Basically, the thing to ask is what data does the company use? And there's this thing called the AACRAO database, and USCIS relies on that database as the authoritative source for equivalency assessment. So just make sure that the company that you're choosing is relying on AACRAO data. Regarding self-petitions, how can I write self-petitions is one question, and I actually highly discourage someone to write a self-petition, and there are many reasons why. And one of the reasons why is because there are very specific legal arguments that you can make and that you can't make. So, and there are some pitfalls in the NIW literature that you can unintentionally get yourself into, like if you don't have the advice of a lawyer. So, for example, like a very common misconception is, oh, the U.S. has a shortage of pilots, so any pilot can be approved for an NIW. That is a very popular myth that is circulating in the internet a lot. So, if you rely on those, snippets of information, maybe you will end up using an argument in your petition letter that does not help you and even paints your petition in the wrong light, even if you have a very strong profile. So I would say I would recommend to all petitioners to definitely get the advice of a lawyer, because if you make the wrong impression in the first try, you may get a denial even if you have a very strong case. So definitely a word of caution for potential petitioners.
All right. Thank you, Gia. I think that was it. There was another question about technical issues, but hopefully that's solved. So I think that concludes our presentation today. Thank you so much, Gia. I appreciate it.
Thank you, Hughes. Thank you, everyone,
Thanks.
for your participation.